speaker is Ms. KERL Fernando, an undergraduate of the Faculty of Law, General Sir John Pathalabia Defence University, and she also follows the diploma course in Human Rights at the Center for Studies of Human Rights at the University of Colombo, Sri Lanka. And she will enlighten us on police powers during demonstrations, legal challenges in the Sri Lankan context.
Thank you, sir. Good afternoon to you all. Vice Chancellor, General Sir John Pathalabia University, Dr. Pratibha Mahanamikeva, Dean, Faculty of Law, Honorable Chairperson, distinguished gathering, ladies and gentlemen. The research arena to be present is executing police powers during demonstrations, legal challenges in the Sri Lankan context. In per se, it is undoubted that among various police duties, this is the most topical, controversial, as well as the most challenging police function exercised in the present context. Therefore, the objective of this paper is to educate the police officers and the civil majority regarding the responsibilities executed by the police force during demonstrations. I believe this is one of the most suitable topics to discuss regarding law and development in the 21st century. Initially, the main purpose to establish a police force in a country is to preserve peace and public order in a society. As a result, Ceylon Police was legally established in 1865 by the Police Ordinance. Following that, the beginning of the Sri Lankan present police service commenced on 3rd September 1866. This research is based on the qualitative research methodology, where the practical experiences of both police officers and civil experts were highly concerned simultaneously with the applicable legal standards. According to the research findings, the criteria of executing police powers during a demonstration can be summarized into 3 stages. First step includes 3 components such as demonstration, protest, and peaceful assembly. Here, even though they emphasize 3 literal meanings, as per the view of executing police powers, the practical behavior of these 3 aspects are equal. Basically, the word demonstration is a synonym of the word protest, which also can be regarded as a peaceful assembly. This first step is out of bound of police powers, since this behavior does not evolve to violate the peaceful order in the country. And on the other hand, most importantly, it signifies the fundamental right to demonstrate. This first step can develop to the second stage of an unlawful assembly, even by a single violent act of a protester. Thirdly, riot is the most advanced violent step of this process, where the word itself carries a negative meaning. According to the research, when a demonstration evolves to a riot, it definitely passes the step of an unlawful assembly. Moreover, protesters can discontinue the demonstration at any of these stages, but the police force is given powers to discontinue only when it evolves to an unlawful assembly or later to a riot. Because during the 2 final steps, it amounts to violate the peace and public order of the society, so as well as the fundamental right of the others. Conflict of interest between the fundamental rights of the demonstrators and the police powers were highlighted in 2 landmark cases. In the case of Vivian Gonawardena, the right to demonstrate was granted by the Supreme Court decision. But in contrast, in Bernard Sosa vs. Attorney General, Supreme Court held that public places cannot be regard to the prevailing procedures of police ordinance and department orders. The police ordinance was lastly amended in 1974. The demonstration situations in the 1970s society and the present context have vast difference. Therefore, this research recommends that new laws should be enacted in order to overcome the prevailing legal challenges of this era. Similarly, under the department orders, the sequence of open fire has become unsuccessful due to the complexity of demonstration held today. Because in a practical clash, the provided procedures are complex to decide whether to open fire or not. This issue was recently arose during the 2011 Katunayaka demonstration. Next, it is an utmost important to use minimum power to resolve a protest. On the other hand, it is also essential to mobilize the police riot squad rather than get other assistances. These loopholes were highlighted during the Katunayaka demonstration in 2011, which also resulted the resignation of Inspector General of Police for using excessive powers and unauthorized measures to dissolve a riot. Moving on, it is essential to strike a legal balance between police and security forces of holding responsibility to dissolve a riot. This became prominent during the recent incident of Rathapassala. According to Section 94 of the Criminal Procedure Code, when security forces summoned by police, they are under the power of the police orders, then the responsibility remains with the police department. But according to the Gazette notification of 2013, President authorized the security forces to engage in maintenance of public order, where the responsibility no longer remains with the police department. Therefore, because of the 2013 Gazette notification, as occurred in Rathapassala, it becomes a controversial issue that who holds the responsibility of firing. Thus, this research recommends Section 95 of Criminal Procedure Code as the most suitable law, since the responsible authority is clearly specified. Next, it is important to discuss the security of police officers during a riot. This fact was immensely discussed after the death of OIC Morales during the riot in Hungary. Therefore, this research recommends that police officers must take legal precautions to prevent the harm which can occur not only to the public but also to them. So, it is paramount to establish new laws within the police department for the protection of police officers during the demonstration. Using the advantage of new technology to dissolve a riot was recently seen in the Uva province of Sri Lanka. During the anti-Muslim riots, police found a threatening video clip of the protesters which notified of holding a riot in the near future disrupting the public order. So, police took a court order to prevent it using the evidence of the video recording. Similarly, in Badalkumbala, that's the area in the Monragal district, police video recorded the whole protest and later summoned the suspects and also claimed the road damages done during the riot. In all these both situations, with the help of the new technology, police has performed their duty in a neutral manner. This research recommends it is a better solution than clash with the protesters and pay the valuable lives of both sides as were occurred in earlier clashes. I conclude the presentation with the objective of upholding the fundamental rights of citizens to demonstrate while allowing execute its duties within the legal framework. Reference